Welcome to Workplace Wake Up, your go-to podcast for practical employment law guidance. I'm Jennifer Shaw, the founder of Shaw Law Group, and I'm here to help HR professionals and leaders navigate the legal minefield of the modern workplace. Each week, we tackle real-world issues with clear advice and a little tough love. Let's get started. Oh my gosh, I cannot believe we are more than halfway through August. Okay. Actually, it has not been too hot this summer in Sacramento. It's definitely warmed up here in August, but July was perfectly lovely. June was amazing. So I hope you all have enjoyed the kind of summer we have had here in terms of weather. Many of you know that my secret love is wage hour law. I love it. I think it is like a puzzle. It is like baking, right? It is precise. A quarter teaspoon of baking soda, a half a cup and an extra tablespoon of sugar. That's how you're going to get your best brownies, right? I love that. So I decided I want to talk for a few minutes here today about the things that should be keeping you up at night when it comes to wage hour law. Now, I'm not saying they are keeping you up, but they should be. And if they aren't, I want you to give some thought to them. As many of you know, Elena Schroeder in our firm does audits for employers, and she does a great job. She has built this audit practice, and she really does an amazing job at getting those employers to understand what they need to do differently and how to solve their problems. We call that audit remediation, okay? And the most common thing that clients want us to audit is, of course, wage hour laws, because in California, we have the Private Attorney General's Act, which actually rewards employers pretty significantly if they do an audit and take steps to fix any problems that are identified. So, wage and hour is always something you should be focused on. What are the things that I want you to be worried about? Okay, these are the things that the HR pros actually think about on a regular basis, okay? Especially in California. First of all, meal periods. All right, I know we had that Brinker decision a decade and a half ago. Yes, we know the decision requires us to provide the meal period, and we know all the rules based on the wage orders about when you take the meal period and how long it needs to be for and what you need to be able to do during your meal period and when you can have an off-duty meal period and when we can require on-duty meal period. All of those things are critical. But get this, you guys, people keep messing up when you have to begin the meal period. And under most wage orders, the meal period, if you're going to work more than 5 hours, okay, if you're going to work more than 5 hours, the first meal period cannot begin after the end of the 5th hour at work. Or said differently, the first meal period must begin before the end of the 5th hour at work. And the second meal period must begin before the end of the 10th hour at work. And remember, you don't even need it until you work 10 hours. Now, there are waivers that come into play here. Waivers, of course, must be in writing. But here's how you count the hours, folks. Let's say somebody comes on at 9 a.m. 9 to 10 is hour 1. 10 to 11 is hour 2. 11 to 12 is hour 3. 12 to 1 is hour 4. And 1 to 2 is hour 5. That means you must begin the meal period before the end of the 5th hour, which is 1:59 p.m. It is not 2:59. It is not 2 o'clock. It is 1:59 p.m. This should keep you up at night. Why? Because you're going to have payroll companies that are rounding meal periods, that are not making sure that that employee started their meal period before the end of the 5th hour at work. If you have an external payroll provider, you better make sure they understand California law, because my experience is many of them do not. And they're not going to help you. They're going to say, fill out our checklist and tell us how you want us to handle this, and that's what we'll do. And they're not going to lift a finger to help you because they're worried about California compliance as much as you are. And by the way, in the agreements you sign with them, they're going to say that we're not indemnifying you if you get sued for this. That's your problem. You got to tell us how to set this up. We're not giving you legal advice. So you've got to make sure that your timekeeping systems are set up correctly. Now, a related issue is rounding of time generally, right? We're talking about rounding of meal periods a moment ago, but let's just talk about rounding of time generally. Okay, you all know the only reason we ever rounded time is because we can't do math, okay? Because why would we round time? If somebody can write on their time card 8:58, before we had electronic time cards, they could write 8:58 and they could write that they went to lunch at 10:28 and they came back at 10:59 and they left at the end of the day at 4:27. That's what they should be writing. But the reason we didn't do that is it's hard to do the math. So we allowed rounding, okay? But the court, particularly the California Supreme Court, has been really chipping away at this rounding idea for a long time. And the court is really saying, you know what? If you have an electronic timekeeping system that tracks when your person clocked in and when your person clocked out for lunch and when they clocked back in after lunch and when they clocked out at the end of the day, that's the time you should be using. Because the only reason you're rounding is you don't want to do the math and you might be able to eliminate a few minutes of overtime. Okay, and that is not going to be good. It looks like subterfuge. It looks like you're trying to eliminate having to pay employees overtime. So forget about rounding, folks. Just forget about it. Pay them what they actually worked. Forget about rounding. The California Supreme Court is like a millimeter away from throwing the whole practice in the garbage. So you may as well get used to it right now. It's coming, okay? Bonus calculations. All right. People are always telling me, Jen, I have a discretionary bonus. I pay it every December. That is not a discretionary bonus. What they mean is the amount of the bonus is discretionary. They might even mean I don't necessarily give it to everybody. It depends on whether we've had a good year. It depends on their performance score. But that doesn't make it discretionary because if we had a good year and you got a good performance score, you're going to get a bonus. A discretionary bonus is literally, hey, everybody, happy Tuesday. Here's $100. Hey, everybody, happy Thanksgiving. Have a turkey. Hey, everybody, I bought you all a box of See's candy for the holidays. Enjoy. That is a discretionary bonus. Very little else is a discretionary bonus. And why do you care? Because of the regular rate of pay. Remember that overtime is paid at the regular rate of pay. Now, what does that mean? Well, if you have an employee who's making $20 an hour and they don't get any other compensation, no bonuses, no incentives, no commissions, no nothing. They just get $20 an hour for all the hours they work and time and a half or double time if they work overtime. If they're only getting $20 an hour, their base rate is the same as their regular rate. So that means the regular rate of pay that you use to calculate overtime is that $20 rate because that's all they get paid. But as soon as you start adding non-discretionary bonuses, commissions, reporting time pay, all of these other kinds of things, you have to include those in the calculation of the regular rate of pay. Okay? That's critical. So anytime you are paying compensation that is more than just a single base hourly rate, you are going to have a regular rate of pay challenge or opportunity. You should be laying awake at night worrying about the regular rate of pay because you may have it right in your head, but the payroll company is not doing it right, or you may not understand it, which is perfectly appropriate and understandable. You're not going to know everything, but I want you to really think about the regular rate of pay and look at your pay stubs. Okay, after this podcast today, look at your pay stubs. Are you paying them correctly? And we're talking about non-exempt employees only, and only non-exempt employees who work overtime. Those are the people we have to be worried about when it comes to the regular rate of pay. Okay? All right. Another issue that I want you to think about, on-call time. In California, we have a number of factors that go into on-call time. What's on-call time? Hey, Jen, we have this list of people who we're going to call if somebody calls in sick because we're a home health agency and we need to make sure that everybody is taken care of. And we can't meet our ratios if we don't have all of our people in. So even if you're not scheduled on a shift, you're going to be put on call. And if we call you to come in, you got to come in. Okay? And if we don't call you to come in, then you were just on call. That is what's called controlled standby or controlled on call. You must pay them at least minimum wage for sitting around waiting for the phone to ring because you told them they have to come to work. On the other hand, if you say, hey, we want to be able to cover our shifts, we don't know who's available and who isn't, we've got a phone tree and we're just going to go down the phone tree and we're going to decide as soon as somebody answers, we're going to ask them if they're willing to come in. And if they are, that's great. We'll give them this extra compensation and we'll give them this extra little benefit because they've said yes. That is uncontrolled standby. Uncontrolled standby, you don't have to pay for. Controlled standby, you do. Now, you can pay it at a different rate than their base rate of pay for their regular work. It can be at minimum wage, for example. You might be paying much more than that for their regular work, but you can absolutely do that. Now, there was a twist on-call time a couple of years back that is really mucking employers up. If you say to someone, I need you to call in and see if you have to work today, so you have to call in by 8:30, and then I'll let you know by 10 if you've got to come to the store, all right? That is controlled standby. That is controlled on-call time for which the employee must be paid, okay? So you can pay a different rate for the actual work they're doing and less for the on-call time, for the controlled on-call time. But you got to pay at least minimum wage. And a lot of employers think, well, I didn't tell them they had to be here in 5 minutes. Okay, but you said they can't drink a beer. And you said they have to respond in 30 minutes, right? And you said they have to be prepared to answer questions coherently. So they can't be drinking at a barbecue that's 4 hours away. So it's a continuum. The more you're imposing on your employees' private life and making them sit around to work, which is called in the industry engaged to wait, okay? The more you are engaging them to wait, the more likely it is that that standby time or that on-call time is controlled, okay? Meaning you're going to have to pay them for it. Now, do you ever have to pay exempt employees for on-call time? No. You can if you want to give them an incentive, you want to give them a little kicker, but most of these wage hour rules are applicable to your non-exempt employees. And remember, every employee in the state of California is presumed to be non-exempt. It will always be your burden to show that somebody is exempt. And what does that phrase mean, exempt? It means they're exempt from most of these wage hour laws. That's why we call them exempt, right? So remember, if you have an exempt employee, you don't have to worry about these rules, right? The vast majority of wage hour rules are intended to protect non-exempt employees. You may be in a situation where you have exempt employees record their time off because you want to be able to track how much time off are they taking. That's reasonable, but you're not adjusting their salary, right? You're just saying track the PTO you use, track the vacation you use. Okay, so the things we've talked about here today, all right, I want you to think about them. Meal periods, bonus calculations, on-call time, right? These are rules that you must comply with, and they are tricky. And there are all sorts of different interpretations, and you have to figure out what you're going to do and where you might be willing to take some risk. But I want you to think about it. Too many times I have employers who say to me, I'm just going to close my eyes and plug my ears and hope for the best when it comes to wage hour. You can do that, but the consequences of getting this wrong are significant. So when you're looking at wage hour compliance, should you have someone in your organization who's focused on that exclusively? Depending on your size, you sure should. Somebody's got to understand off the top of their head, literally, because they have scoured the law, they have scoured the regulation, they've scoured the DLSC's information, they've scoured the Fair Labor Standards Act because it applies in many ways in California, right? You need someone who's willing to do that in your organization. And then you won't have to stay up all night worrying about wage hour issues, okay? Thanks everyone for joining me today. It's such an honor and privilege to work with you. Keep up the good work and I'll see you next time. Workplace Wake Up, including our guests and hosts, do not provide legal advice in this podcast. Do not act upon any of the information discussed in this podcast without first consulting a licensed attorney in your jurisdiction. Thank you for joining me on this episode of Workplace Wake Up. If you found today's discussion helpful, be sure to subscribe, leave a review, and share the podcast with your HR and leadership teams. For more insights, training programs, and legal updates, you can visit us at shawlawgroup.com.